I was standing in my driveway, staring at what used to be my pride and joy when I realized that some people really do take their power trips way too seriously. My 2019 Ski-Doo Summit X Snowmachine sat there in pieces, the engine cowling cracked open like an egg, wires hanging out like intestines, and what looked like deliberate scratches carved into the tunnel. This was not vandalism by some random teenager. This was calculated destruction, and I had a pretty good idea who was behind it. My name is Frank Bradford, and I have lived in the Pine Ridge Estates community in Anchorage, Alaska, for 5 years. When my wife passed away 3 years ago, I threw myself into my hobbies to cope with the grief. Snow machining became my escape during those long Alaskan winters. I would take my Summit X out into the backcountry every weekend, carving through fresh powder, feeling the cold air bite at my face through my helmet visor. It was freedom. It was therapy. And now it was destroyed. The morning started normally enough. I woke up at 6, made my coffee, and looked out my kitchen window to see if the snow had stopped. That is when I saw her. Patricia Whitmore, the HOA president, standing at the end of my driveway with her phone out, taking pictures. She was wearing her typical outfit, a purple parka that was probably worth more than my monthly mortgage payment, designer snow boots that had never seen actual snow until she moved to Alaska 2 years ago, and that expression. You know the one. The pinched face of someone who has made it their life mission to find fault in everything around them. I opened my front door and stepped out onto the porch. "Can I help you with something, Patricia?" She looked up from her phone, and I swear I could see the gears turning in her head as she prepared whatever complaint she had brewing. "Good morning, Frank. I am documenting violations of the community covenants." Violations. I walked down the steps toward my driveway. That is when I saw my snow machine. "What the hell happened?" "Language, please," Patricia said, her voice dripping with false politeness. "I had the HOA Enforcement Committee inspect your property yesterday evening. Your snow machine has been in violation of Section 12.4 of our community guidelines, which states that all recreational vehicles must be stored in an enclosed garage or behind a privacy fence at least 6 feet tall. Your machine has been visible from the street for 3 weeks now." My hands clenched into fists at my sides. "So you destroyed it? Are you completely insane?" "We did not destroy anything," she said, examining her manicured nails. "We exercised our right under Section 18.7 to remove violations from the property when the homeowner fails to comply after receiving proper notice." "I never received any notice." She pulled out a folder from under her arm and handed me a piece of paper. It was dated 3 days ago, supposedly a violation notice left on my door. I had never seen it before in my life. "This is dated when I was out of town for work," I said, my voice rising. "I was in Fairbanks for 4 days. I just got back last night." How was I supposed to respond to something I never saw? Patricia smiled, and it was the kind of smile that made me want to throw something. "Ignorance of the notices is not an excuse for non-compliance. The snow machine has been removed from your property. You may pick up the remains at the community storage facility on Maple Road. Have a good day, Frank." She turned and walked away, her boots crunching in the fresh snow. I stood there, trembling with rage, staring at the paper in my hand. This could not be legal. There was no way the HOA had the right to come onto my property and destroy my personal belongings. I pulled out my phone and called my buddy Marcus, who worked as a paralegal downtown. He answered on the 3rd ring. "Frank, what is up?" "The HOA destroyed my snow machine. I need a lawyer." There was a pause. "What do you mean destroyed?" I explained everything while walking around my property, looking for any other damage they might have caused. My hands were shaking from the adrenaline and anger coursing through me. "Okay, first thing, take pictures of everything," Marcus said. "Document all the damage, then file a police report. What they did sounds like destruction of property, which is a crime. After that, call Thomas Brennan. He is a lawyer here in Anchorage who specializes in HOA disputes. I will text you his number." I spent the next hour photographing every angle of the destruction. The cowling was not just removed but had been pried off with something like a crowbar, leaving deep gouges in the fiberglass. The seat was slashed. The instrument cluster was smashed. This went beyond simply removing a violation. This was vindictive. The police arrived around 9. Officer Rodriguez stepped out of his cruiser and approached me with a notepad in hand. He was in his mid-30s, stocky build, with the tired eyes of someone who had seen too much stupidity in his career. "You called about property destruction?" he asked. I showed him the Snowmachine and explained the situation. He walked around it, taking his own photos and making notes. His expression grew more serious as I told him about Patricia and the HOA. "Did you give them permission to enter your property?" "Absolutely not." "Do you have any security cameras?" I kicked myself mentally. "No. I have been meaning to install some, but I never got around to it." Officer Rodriguez nodded. "I am going to write up a report for criminal mischief and destruction of property. The value of the damage looks like it exceeds $1,000, which makes this a misdemeanor at minimum. Do you know the approximate value of the Snowmachine?" "I paid $22,000 for it new. It had maybe 3,000 miles on it, always maintained. It was probably worth $18,000 before they did this." He whistled low. "That bumps it up to felony territory. I am going to need to talk to this Patricia Whitmore and anyone else involved in the HOA decision." She mentioned an enforcement committee. "You know who else is on it?" I thought for a moment. "I think Gerald Thompson and Susan Chen. They are both on the HOA board." Officer Rodriguez made notes. "I will follow up with them. In the meantime, do you have insurance on the machine?" "Yes, comprehensive coverage through Alaska Mutual." "Good." "File a claim, but make sure to tell them there is a police investigation ongoing. The report number is going to be 2025 ANC 04471. You will get a copy emailed to you within 24 hours. After he left, I sat in my living room trying to calm down. My hands were still shaking. The Snowmachine was not just a toy to me. It represented the time I spent healing after Sarah died. Every trail I rode, every mountain I climbed with that machine was a memory of learning to live again. I called the lawyer, Thomas Brennan. His receptionist put me through after I explained it was urgent. "Mr. Bradford, I understand you are having issues with your HOA," Brennan said. His voice was calm and professional, with a slight Texas drawl that seemed out of place in Alaska. I explained everything again, and I could hear him typing on his computer as I spoke. "Okay, here is what we are looking at," he said when I finished. "First, what they did was absolutely illegal. HOAs have certain rights to enforce covenants, but they cannot destroy property without a court order. They can fine you. They can put a lien on your house for unpaid fines, but they cannot physically damage your belongings. Second, the fact that they claim to have left notice when you were out of town is going to work in our favor. Third, Alaska has pretty strict laws about trespass and property rights. So what do? We sue them. We file a civil lawsuit for destruction of property, trespass, and intentional infliction of emotional distress. We are going to ask for the full replacement value of the Snowmachine plus damages. I am also going to file an emergency motion for a restraining order preventing them from taking any further action against you or your property. How soon can you come to my office? I can be there in 30 minutes. Brennan's office was in a modern building downtown with a view of the Chugach Mountains. His receptionist, a young woman named Emily, offered me coffee while I waited. I was too worked up to drink it. Brennan came out to greet me personally. He was in his 50s, tall and thin with graying hair and wire-rimmed glasses. He shook my hand firmly and led me back to his office. "Let me see everything you have," he said. I showed him the photos on my phone, the fake notice Patricia had given me, and the police report number. He examined everything carefully, occasionally asking questions. "This is good," he said finally. "This is really good for us, I mean. Bad for them. The fact that they documented their own actions, that Patricia took photos this morning, that is going to be evidence of their intent." "When did you say you bought the Snowmachine?" "December 2019. I have the receipt at home and all the maintenance records." "Perfect. I am going to need all of that. Also, any documentation about your HOA, the covenants, any previous correspondence with them, anything at all." I thought back. "I've gotten a few violation notices over the years. Stupid stuff. My grass was a 1/4 inch too tall once. I had a Christmas decoration up 2 days past the deadline another time. All minor things that I fixed immediately." "Did you keep those notices?" "I think so. They might be in a file cabinet at home. Get me everything. The more we can show a pattern of harassment and overzealous enforcement, the better." He leaned back in his chair. "Now, I need to be straight with you about costs. A case like this could take 6 months to a year to resolve. My retainer is $5,000 and my hourly rate is $300. However, if we win, and I am confident we will, we can ask the court to award attorney fees as part of the judgment." I thought about my savings account. 5,000 would hurt, but this was about more than money now. This was about principle. "Let us do it," I said. We spent the next 2 hours going over every detail. Brennan had me write out a timeline of events, a detailed description of the Snowmachine and its condition before the destruction, and a statement about how I used it and what it meant to me. "The emotional distress claim is going to hinge on the connection between the Snowmachine and your late wife," he explained. "I am not trying to exploit your grief, but the jury needs to understand that this was not just property to you. It was a tool you used to heal." I nodded, swallowing hard. Talking about Sarah was still difficult, even after 3 years. When I left his office, it was past 2 in the afternoon. I drove home and immediately started gathering documents. I found the file with the old violation notices. Reading through them now, I could see the pattern Brennan had mentioned. Every notice was for something trivial, and every one was from Patricia. She had been on my case since she became HOA president 18 months ago. There was a knock on my door around 4. I opened it to find my neighbor, David Chen, standing there with a concerned expression. David was in his early 40s, an engineer at the university, and generally one of the few reasonable people in the neighborhood. "Frank, I heard what happened," he said. "Susan told me about the HOA meeting last night." Susan was his wife, and one of the HOA board members Patricia had mentioned. I invited him inside. "What exactly did Susan say?" I asked. David looked uncomfortable. "She said Patricia called an emergency enforcement committee meeting. My wife did not want to go, but Patricia insisted it was urgent. When she got there, Patricia told her and Gerald that your Snowmachine was a violation and that they needed to authorize its removal." "Removal? They destroyed it, David." "Susan did not know they were going to do that. She thought they were going to have it towed to a storage facility. Patricia told them you had been sent multiple notices and refused to comply. Susan signed off on the authorization because she thought you were being stubborn." I felt my anger spike again. I never got any notices except the one supposedly left 3 days ago when I was out of town. Patricia knew I was gone. I mentioned it to her at the community meeting 2 weeks ago. David rubbed his face. Susan feels terrible. When she drove past your house this morning and saw what they did to the machine, she was horrified. That is not what she authorized. Is she willing to testify to that? Testify? Frank, are you suing? I already hired a lawyer. And I filed a police report. What Patricia did was criminal. David sat down heavily on my couch. This is going to tear the neighborhood apart. Good. Maybe it is time people realized what kind of person Patricia really is. He left a few minutes later, promising to talk to Susan about what she knew. I spent the rest of the evening organizing documents and sending them to Brennan via email. The next morning, I received a call from my insurance company. The adjuster, a woman named Jennifer, had reviewed my claim and the police report. "Mr. Bradford, I have some good news and some bad news," she said. "The good news is that your claim is approved. The damage clearly falls under your comprehensive coverage. The bad news is that the payout is going to be based on the actual cash value of the machine, which factors in depreciation. Based on the year and mileage, we are looking at approximately $16,000. But I am going to need at least $25,000 to replace it with a comparable new model," I said. "The new Summit X starts at $24,000 base price." "I understand, and that is something you will need to pursue with the responsible party. Our obligation is to compensate you for the loss of the vehicle you had, not to upgrade you to a new one." I thanked her and hung up, frustrated but not surprised. That was how insurance always worked. At least I would have $16,000 to start with. Brennan called me later that day. "I have some interesting news." Officer Rodriguez followed up with Patricia Whitmore this morning. She admitted to authorizing the removal of the Snowmachine, but claims she hired a licensed towing company to do it. The problem is, the towing company she named has no record of any such job. So she is lying. Looks that way. The police are expanding their investigation. They are going to pull any video footage they can find from nearby properties and businesses. If they can prove Patricia or someone acting on her behalf directly caused the damage, she could be facing serious charges. What about the lawsuit? I filed the complaint this morning. Patricia and the HOA will be served within the next few days. I also filed for a temporary restraining order and an emergency hearing. We should get a court date within 2 weeks. The waiting was the hardest part. I tried to keep busy with work, but my mind kept drifting back to the destroyed Snowmachine. I found myself looking out the window at the empty space where it used to sit, feeling the anger build each time. 3 days after the police report was filed, Officer Rodriguez called me. "Mr. Bradford, I wanted to give you an update. We obtained security footage from a business 2 blocks from your house. The camera faces the street and caught a white pickup truck driving past around 7 p.m. on the night in question. The truck bed has what looks like parts of a Snowmachine in it. We are working on enhancing the image to get a plate number." "That is great," I said. "There is more. We executed a search warrant on Patricia Whitmore's property this morning. We found tools in her garage that had traces of what appears to be fiberglass and plastic consistent with Snowmachine parts. She has been arrested for felony criminal mischief and is currently being processed." I sat down hard. She actually did it herself. Looks that way. We also found a notebook in her home office with notes about various properties in the neighborhood and what she considered violations. Your property was mentioned multiple times, along with some pretty disturbing comments about teaching you a lesson and making an example. This goes beyond an HOA dispute, Mr. Bradford. This woman has been stalking and harassing multiple residents. After he hung up, I called Brennan and told him the news. I could hear the satisfaction in his voice. "This changes everything," he said. "With criminal charges filed, our civil case becomes much stronger. A criminal conviction would be admissible evidence in the civil trial. Patricia is looking at serious jail time if convicted, and the HOA is going to be desperate to settle to avoid the publicity." "I do not want to settle," I said. "I want a judge to rule on this." "I respect that, but keep an open mind. A good settlement could get you everything you want without the time and stress of a trial." The next few days were chaotic. The story hit the local news. Apparently, a reporter heard about the arrest on the police scanner and started digging. By the end of the week, there were articles in the Anchorage Daily News with headlines like "HOA President Arrested for Destroying Residents' Property" and "Pine Ridge Estates, HOA Under Fire for Overzealous Enforcement." My phone rang constantly with reporters asking for interviews. I declined most of them on Brennan's advice, but I did agree to one interview with a local TV station. The reporter, a young man named Jason, came to my house with a camera crew. "Mr. Bradford, can you walk us through what happened?" he asked, holding a microphone. I showed them the photos of the destroyed Snowmachine and explained the timeline. I made sure to mention that I had never received proper notice and that I had been out of town. "What do you want people to know about this situation?" Jason asked. "I want people to understand that HOAs are supposed to maintain property values and community standards, not terrorize homeowners. Patricia Whitmore abused her position of power to commit a crime, and she needs to be held accountable. But more than that, this is a wake-up call for everyone living in an HOA. You need to pay attention to who is on your board and what they are doing. You need to read your covenants and understand your rights, because if you do not, you might end up like me." The interview aired that evening. Within an hour, my phone was buzzing with messages from neighbors. Some were supportive, thanking me for standing up to Patricia. Others were angry, accusing me of making the neighborhood look bad and hurting their property values. One message stood out. It was from Gerald Thompson, the other HOA board member who had been at the enforcement committee meeting. He asked if he could come talk to me. I agreed, curious about what he had to say. Gerald showed up at my door around 8 p.m. He was in his 60s, retired military, with gray hair cut in a tight crew cut. He looked exhausted. "Frank, I owe you an apology," he said as soon as I let him in. "I signed off on the authorization to remove your Snowmachine because Patricia told me you had been repeatedly warned and were refusing to comply. She said you were being belligerent and that we needed to take strong action. I trusted her, and I should not have." "Did you know she was going to destroy it?" I asked. "God, no. I thought we were hiring a towing company to move it to storage. When I drove past your house the next morning and saw what she had done, I was sick to my stomach. I called her immediately and demanded to know what happened. She told me that the towing company got rough with the machine during the removal and that she would handle it. I believed her because I did not think even Patricia would be crazy enough to do something like that deliberately. But she did. I know that now. The police came and talked to me. I told them everything I knew. I also resigned from the HOA board this morning. I cannot be part of an organization that operates like this." I appreciated his honesty, even if it did not change what had happened. Gerald left after about 20 minutes, and I was alone again with my thoughts. The emergency hearing for the restraining order was scheduled for the following Tuesday. Brennan had explained that this was just a preliminary hearing to prevent the HOA from taking any further action while the main case proceeded. Patricia was not there, obviously, since she was dealing with criminal charges. Instead, the HOA sent their attorney, a slick-looking guy in his 30s named Richard Morrison. Judge Melissa Harper presided. She was in her 50s with short brown hair and a no-nonsense demeanor. She read through the filings quickly and then looked up at both attorneys. "Mr. Brennan, you are asking for a restraining order preventing the Pine Ridge Estates HOA from taking any enforcement action against your client. What is the basis for this request?" Brennan stood. "Your Honor, the HOA president, Patricia Whitmore, has been arrested for felony criminal mischief after destroying my client's personal property. The HOA authorized this destruction under the guise of enforcing community covenants, but they did so without proper notice and without legal authority. My client has a reasonable fear that the HOA may take further action against him or his property while the criminal and civil cases are pending." Judge Harper turned to Morrison. "What is the HOA's position?" Morrison stood, smoothing his tie. "Your Honor, the HOA disputes the characterization of events. While we acknowledge that Miss Whitmore has been arrested, the HOA as an entity was acting within its rights to enforce community covenants. We have since taken steps to ensure proper procedures are followed going forward, including appointing an interim president. We do not believe a restraining order is necessary or appropriate." "Did Mr. Bradford receive proper notice before the HOA took action against his property?" the judge asked. Morrison hesitated. "The HOA left notice on his door 3 days prior to the enforcement action. Was Mr. Bradford home to receive this notice? We are not required to confirm that a homeowner is physically present to receive notice, Your Honor. We only need to make a reasonable attempt to deliver it." Judge Harper's expression hardened. "Mr. Morrison, I have reviewed the police report and the evidence submitted by Mr. Brennan. The notice in question was allegedly left while Mr. Bradford was out of town for work. The HOA president had been made aware of his absence at a prior meeting. That does not sound like a reasonable attempt to provide notice. It sounds like an intentional effort to deprive Mr. Bradford of his right to respond. Your Honor, I am not finished. Even if proper notice had been given, nothing in the HOA covenants authorizes the destruction of personal property. The HOA could have sought a court order. They could have imposed fines. Instead, they took the law into their own hands, and now a woman is facing felony charges. I am granting the restraining order. The Pine Ridge Estates HOA is prohibited from taking any enforcement action against Mr. Bradford or his property pending resolution of the civil lawsuit. Any violation of this order will result in contempt charges. Do I make myself clear?" "Yes, Your Honor," Morrison said quietly. As we left the courtroom, Brennan was practically beaming. "That went even better than I hoped. Judge Harper is known for taking a dim view of HOA overreach. Having her assigned to this case is a stroke of luck for us." "What happens next?" I asked. "The HOA has 30 days to file a response to our complaint. After that, we go into discovery, where both sides exchange evidence and take depositions. The criminal trial will probably happen before our civil trial, which works in our favor. If Patricia is convicted, it is going to be nearly impossible for the HOA to defend against our claims. Patricia's criminal trial was scheduled for late March, about 6 weeks away. In the meantime, life in Pine Ridge Estates was tense. The neighborhood was divided between those who supported me and those who thought I was overreacting and causing unnecessary drama. The interim HOA president, a mild-mannered accountant named Robert Palmer, reached out to me through Brennan. He wanted to discuss a settlement. Brennan and I met with him and Morrison at Brennan's office. "Mr. Bradford, the HOA recognizes that serious mistakes were made. Robert began. He seemed genuinely uncomfortable with the whole situation. "We would like to make this right without dragging the community through a lengthy legal battle." "What are you offering?" Brennan asked. Morrison pulled out a document. "We are prepared to offer Mr. Bradford $20,000 to cover the loss of his snow machine plus an additional $5,000 for his trouble. In exchange, he would agree to drop the lawsuit and not pursue any further claims against the HOA." I looked at Brennan, who gave a slight shake of his head. "That is not acceptable," I said. "A new Summit X costs at least $24,000, and that is before adding any of the modifications I had on mine. You are not even covering full replacement, let alone damages." "Mr. Bradford, please be reasonable," Morrison started. "I am being reasonable. Your client, through its president, destroyed my property. I am asking for full replacement value plus compensation for the emotional distress and harassment. That is not unreasonable. That is basic fairness." Robert sighed. "What number would you accept?" Brennan leaned forward. "$40,000. $25,000 for a new snow machine with comparable modifications. $5,000 for storage and rental costs while Mr. Bradford was without his machine, and $10,000 for emotional distress. Plus, the HOA covers all attorney fees." Morrison and Robert exchanged looks. "We need to discuss this with the board," Robert said. "Can we have a week?" "You have 3 days," Brennan replied. "After that, the offer is off the table and we proceed to trial." They agreed and left. As soon as they were gone, I turned to Brennan. "Do you think they will accept?" "I think they are scared. The criminal trial is going to be a nightmare for them publicity-wise. If Patricia is convicted, which seems likely based on the evidence, the HOA is going to look terrible. They know that a jury is going to be sympathetic to you and hostile to them. $40,000 is probably cheaper than going to trial when you factor in their legal costs." 2 days later, Morrison called. The HOA rejected the settlement offer but countered with $35,000 all-inclusive. Brennan advised me to take it, but I refused. This was not about the money anymore. It was about making sure Patricia and the HOA faced real consequences for what they did. "Then we go to trial," Brennan said. "But I need you to understand that trials are unpredictable. We could win big or we could lose. Are you prepared for that?" "I am prepared." Patricia's criminal trial began on March 24th. I attended every day, sitting in the back of the courtroom and watching the proceedings. The prosecutor, an assistant district attorney named Lisa Freeman, laid out the case methodically. She presented the security footage showing Patricia's truck near my house on the night in question. She showed the tools found in Patricia's garage with the forensic evidence linking them to my snow machine. She called Officer Rodriguez to testify about the notebook found in Patricia's office with the disturbing comments about me. The defense attorney, a public defender named Mark Stevens, tried to argue that Patricia had only intended to move the snow machine and that the damage was accidental. But Freeman tore that argument apart on cross-examination. "Miss Whitmore, you have testified that you only meant to move the snow machine. Is that correct?" Freeman asked. Patricia, looking pale and tired, nodded. "Yes, I was trying to enforce the HOA covenants." "And you believed you had the authority to enter Mr. Bradford's property without his permission?" "The covenants give the HOA the right to abate violations. The covenants give you the right to enter the property for inspections with proper notice. They do not give you the right to remove or destroy property. You understand the difference, do you not?" I was following the enforcement guidelines. Freeman held up a copy of the HOA covenants. "Can you show me where in these covenants it says you can remove or destroy property?" Patricia's attorney objected, but the judge overruled him. Patricia could not answer the question. Freeman then showed photos of the destroyed Snowmachine. "Miss Whitmore, does this look like the result of simply moving a vehicle?" The machine was difficult to load. The seat was slashed. The instrument cluster was smashed. The cowling was pried off with what forensic experts testified was consistent with a crowbar. Does loading a vehicle typically involve slashing the seat? Patricia had no good answer. The jury could see she was lying, and so could I. The most damning evidence came when Freeman introduced the notebook. She read several entries aloud, each one more disturbing than the last. January 10th. Frank Bradford continues to ignore warnings, must take stronger action. He needs to learn respect for community rules. February 3rd. Bradford was rude to me at the community meeting. He will regret challenging my authority. February 15th. Bradford is out of town. Perfect opportunity to handle the Snowmachine problem permanently. The courtroom was silent as Freeman read. When she finished, she looked directly at the jury. "Ladies and gentlemen, this was not an accident. This was not a misguided attempt to enforce community rules. This was a deliberate, premeditated attack on Mr. Bradford's property because Miss Whitmore felt disrespected. She abused her position as HOA president to commit a crime, and the evidence proves it beyond any reasonable doubt." The jury deliberated for less than 3 hours. They found Patricia guilty on all counts: felony criminal mischief, trespass, and destruction of property. She broke down crying when the verdict was read. Sentencing was scheduled for 2 weeks later. At the sentencing hearing, Judge Michael Torres listened to statements from both sides. I gave a victim impact statement, describing how the destruction of my Snowmachine had affected me and how it felt to have someone abuse their position of power to attack me personally. "Your Honor, I trusted the HOA to act responsibly and within the bounds of the law," I said. "Instead, the president used her position to commit a crime against me. I have lost not just a valuable piece of property, but also my sense of security in my own home. I am constantly worried about what the HOA might do next, even with the restraining order in place." Patricia Whitmore needs to understand that actions have consequences and that no one is above the law, not even an HOA president. Judge Torres sentenced Patricia to 18 months in prison, with all but 6 months suspended. She would serve 6 months, followed by 3 years of probation. She was also ordered to pay full restitution, which the judge set at $25,000 for a replacement Snowmachine. Additionally, she was permanently banned from serving on any HOA board. With the criminal trial concluded, our civil case moved forward quickly. The HOA's attorney filed a motion to dismiss based on the fact that Patricia had been acting outside the scope of her authority, but Judge Harper denied it. The HOA board authorized the enforcement action, Judge Harper ruled. The fact that Miss Whitmore exceeded that authority does not absolve the HOA of responsibility. The board should have exercised better oversight and should not have authorized action without confirming proper notice was given. The case will proceed. Discovery was extensive. Brennan deposed Robert Palmer, Gerald Thompson, and Susan Chen. He obtained all the HOA meeting minutes for the past 2 years, showing a pattern of increasingly aggressive enforcement under Patricia's leadership. He also deposed several other homeowners who had been targeted by Patricia, establishing that I was not an isolated case. One particularly helpful witness was Martha Friedman, an elderly woman who lived 3 houses down from me. Patricia had sent her multiple violation notices for having bird feeders in her front yard, claiming they attracted pests. When Martha refused to remove them, Patricia had shown up one day and physically destroyed the feeders herself. Martha had been too scared to report it at the time, but she agreed to testify after hearing about my case. I thought if I just kept my head down and did not make trouble, she would leave me alone, Martha testified during her deposition. But Patricia was relentless. She would drive by my house multiple times a day, looking for things to complain about. I felt like I was being stalked. The civil trial was scheduled for September. Brennan spent the summer preparing, interviewing witnesses, reviewing documents, and crafting our strategy. He explained that we needed to prove three things: that the HOA authorized the action against my property, that the action caused damages, and that the damages entitled me to compensation. The criminal conviction makes the liability piece easy, he explained. We have a final judgment that Patricia destroyed your property. The HOA authorized her to take enforcement action, so they share responsibility. The question is going to be damages. We need to convince the jury that you are entitled to a brand new Snowmachine, not just the depreciated value of the old one. How do we do that? We emphasize that full restitution requires putting you back in the position you would have been in if this had never happened. You maintained your machine meticulously. It was in excellent condition. The only way to truly replace it is with a new machine of equal quality. We will bring in an expert witness, someone from a Snowmachine dealership who can testify about values and replacement costs. Brennan hired an expert named Tom Richards, who owned Arctic Powersports in Anchorage. Tom had been selling and servicing Snowmachines for 30 years. He reviewed the photos of my destroyed Summit X and all my maintenance records. This was a well-maintained machine, Tom testified at trial. Mr. Bradford kept it in excellent condition. Based on the model year and mileage, in normal circumstances, it would be worth approximately $17,000 to $18,000 on the used market. However, given the extent of the damage, it is not repairable. To replace this machine with one of comparable quality and features, Mr. Bradford would need to purchase a new 2025 Summit X with similar modifications, which would cost approximately $26,000. The HOA's attorney, Morrison, tried to argue that I should only be entitled to the used value, but Tom shut that down. If someone totals your car, the insurance company pays you enough to buy a comparable replacement, not to buy a pile of parts, Tom said. Mr. Bradford cannot buy a comparable used machine because used machines in this condition are rare. The only practical replacement is a new one. The trial lasted 4 days. Brennan called me to testify about what happened and how it affected me. I described my relationship with the Snowmachine, how I used it to cope with Sarah's death, and how devastating it was to see it destroyed. It was not just the financial loss, I said. It was the violation of trust. I pay HOA fees expecting that the HOA will act professionally and responsibly. Instead, they sent someone to destroy my property. I felt violated. I felt unsafe in my own home. Morrison tried to make me seem like I was exaggerating, but I stuck to my story. Everything I said was true. The HOA's defense was weak. They tried to argue that they had relied on Patricia's representations and that they should not be held liable for her criminal actions. But Brennan systematically demolished this argument by showing that the board had failed in its oversight duties. The board authorized enforcement without confirming that proper notice had been given, Brennan argued in his closing statement. They authorized entry onto Mr. Bradford's property without a court order. They failed to supervise Patricia or ensure that the enforcement action was carried out legally. They created the environment that allowed this crime to happen, and they must be held accountable. The jury deliberated for a full day. When they came back, they found in my favor on all counts. They awarded me $26,000 for the replacement Snowmachine, $5,000 for loss of use, $15,000 for emotional distress, and $50,000 in punitive damages. The total judgment was $96,000, plus attorney fees and costs. Judge Harper entered the judgment and made it clear that she expected the HOA to pay promptly. The HOA will pay the full judgment amount within 60 days, or I will authorize Mr. Bradford to place a lien on the HOA's assets and pursue collection remedies. Am I understood? Morrison nodded weakly. Yes, Your Honor. As we walked out of the courthouse, I felt a weight lift off my shoulders. It had been a long 9 months since Patricia destroyed my Snowmachine, but justice had finally been served. Congratulations, Brennan said, shaking my hand. You stood up for yourself and won. Not many people have the courage to take on an HOA like this. I could not have done it without you. You did the hard part. You refused to back down when they tried to intimidate you. The HOA paid the judgment in full within the 60-day deadline. I used the money to buy a brand new 2025 Ski-Doo Summit X, fully loaded with all the modifications I wanted. It cost $28,000 after taxes and fees, but I had plenty left over to cover the difference. The first time I took the new machine out into the backcountry, I felt a sense of peace I had not experienced since before Sarah died. The snow was perfect, the sky was clear, and the mountains stretched out endlessly before me. I opened up the throttle and flew across the powder, feeling free. Back in Pine Ridge Estates, things changed significantly after the trial. Robert Palmer remained as HOA president and instituted major reforms. The HOA adopted new procedures requiring multiple notices before any enforcement action, mandatory oversight of any property access, and regular audits of enforcement decisions. They also created a homeowner appeal process so that residents could challenge violation notices without having to go to court. Several homeowners who had been too afraid to speak up during Patricia's reign came forward with their own stories of harassment. The HOA board issued formal apologies and resolved many of the disputes informally. Martha Friedman got new bird feeders, paid for by the HOA. Gerald Thompson rejoined the board after the reforms were implemented, bringing his military discipline and fairness to the role. Susan Chen became the vice president and worked hard to rebuild trust with the community. As for Patricia, she served her 6 months in jail and was released on probation. I never saw her again. I heard through the neighborhood grapevine that she moved out of state to live with her sister in Oregon. Part of her probation required that she attend anger management classes and perform community service. I hoped, for her sake, that she learned something from the experience. The legal battle had been exhausting and stressful, but it taught me important lessons. I learned that standing up for yourself is worth it, even when it is hard. I learned that HOAs have power, but that power has limits. Most importantly, I learned that the legal system, for all its flaws, can still deliver justice when good people refuse to be bullied. My new Snowmachine sits in my garage now, properly stored behind a privacy fence I installed to comply with the HOA covenants. I do not have any problems with the HOA anymore. When I see Robert Palmer at community meetings, we greet each other cordially. The neighborhood has healed mostly, though there are still some residents who think I should have just moved the Snowmachine when Patricia first complained. Those people do not understand the principle at stake. It was never really about the Snowmachine. It was about whether one person could abuse their authority to punish someone they did not like. It was about whether property rights mean anything when you live in an HOA. It was about standing up to bullies, even when they have official titles and the backing of an organization. I won because I refused to be intimidated. I won because I documented everything and followed the proper legal channels. I won because I had a good lawyer and a fair judge. But mostly, I won because I knew I was right and I was willing to fight for it. Every time I fire up the Summit X and head out into the wilderness, I think about how close I came to just accepting what happened. I could have taken the insurance payout and let it go. I could have moved to a different neighborhood without an HOA. I could have let Patricia win. But I did not, and that made all the difference. The legal fees were substantial, even with the court order requiring the HOA to pay my attorney fees. There were costs not covered by that order, and it took several months to get fully reimbursed. But every penny was worth it. Brennan and I stayed in touch after the trial. He called me a few months later to tell me that he had received 3 new clients, all HOA disputes, who had been inspired by my case. Word was spreading that homeowners did not have to simply accept whatever their HOA demanded. "You started something," Brennan told me. "Other people are standing up for themselves now. That is a good thing." I hoped he was right. HOAs serve an important purpose in maintaining neighborhoods and property values, but they need to be kept in check. Too often, they become little fiefdoms run by people who enjoy having power over their neighbors. My case showed that there are consequences for that kind of abuse. The criminal restitution from Patricia came in slowly. She was required to pay $200 a month as part of her probation, which barely made a dent in the $25,000 she owed. Her attorney filed paperwork arguing that she could not afford more than that on her limited income. Judge Torres was not sympathetic, but did not want to set up a payment plan that would be immediately violated, so he allowed the smaller monthly payments. I did not care much about getting money from Patricia personally. The civil judgment against the HOA had made me whole financially. The criminal restitution was more about the principle and about ensuring she faced real consequences. Life gradually returned to normal. I went back to focusing on my work as a civil engineer and spending my weekends in the backcountry. The stress of the legal battle faded, replaced by satisfaction at having fought, and one unexpected benefit of the whole ordeal was that I became much more involved in the HOA. I started attending meetings regularly, not to cause trouble but to keep an eye on things and make sure the reforms were actually being implemented. Other homeowners who had been inspired by my case also became more active, and the meetings went from being rubber stamp sessions, where Patricia had made all the decisions, to actual discussions about community issues. We voted to reduce the HOA fees slightly since we were no longer paying Patricia's salary. She had been taking a small stipend for her work as president, which Robert declined. We also voted to require board meetings to be recorded and posted online for transparency. These might seem like small changes, but they made a big difference in how the HOA operated. Transparency and accountability became the new normal, and the neighborhood was better for it. I also became friendly with several homeowners I had not known well before. Going through the trial created connections with people who had supported me. Martha Friedman invited me over for coffee occasionally, and we would talk about gardening and birds. David and Susan Chen had me over for dinner a few times. Even Gerald Thompson and I developed a mutual respect, bonding over our shared frustration with how Patricia had manipulated everyone. The media attention from the case eventually faded, but the story lived on in local HOA circles. Brennan told me that attorneys across Alaska now used my case as an example when advising HOA boards about the limits of their authority. Some called it the Bradford precedent, which made me uncomfortable because I had never set out to create any kind of precedent. I had just wanted justice for what happened to me. As winter approached again, I prepared for another season of snow machining. The new Summit X was broken in nicely, running smooth and strong. I had added a few extra modifications, including a better GPS system and upgraded shocks. It was, objectively, a nicer machine than the one Patricia destroyed, though I would have preferred to still have my old one with all its memories attached. On the anniversary of the day Patricia destroyed my original snow machine, I took the new one out for a long ride. I went to some of my favorite spots, places Sarah and I had visited before she got sick. The mountains were beautiful, covered in fresh snow that sparkled in the sunlight. I stopped at a ridge overlooking a vast valley and took off my helmet, breathing in the cold air. I thought about everything that had happened over the past year, the anger and violation I felt that morning when I saw what Patricia had done, the stress of the legal battle, the satisfaction of winning, the friendships formed and the community improved. Most of all, I thought about Sarah. She would have been furious about what Patricia did, and she would have been proud of me for fighting back. Sarah had always hated bullies and had taught me to stand up for what was right, even when it was difficult. I did it, I said aloud to the mountains. I stood up for myself and I won. The wind carried my words away, but I felt like Sarah heard them somehow. I put my helmet back on and headed down the ridge, carving through the powder with a sense of freedom and peace. The legal system had worked the way it was supposed to. Patricia was held accountable for her crime. The HOA paid for the damages they caused. I got my justice and a brand new snow machine. It was not a perfect resolution because nothing could undo the violation I felt or give me back the sentimental value of my original machine, but it was as close to perfect as real life gets. As I rode back toward the trailhead, I reflected on the lessons from the experience. Document everything. Know your rights. Do not be afraid to stand up to authority when that authority is being abused. Find a good lawyer. Be patient because justice takes time. And most importantly, do not let anyone make you feel like you should just accept being wronged, because fighting back is inconvenient or uncomfortable. I unloaded the snow machine from my trailer at home and backed it into the garage. The privacy fence I had installed stood tall and solid, technically complying with the HOA covenants while also serving as a reminder that I knew my rights and would not be pushed around. Robert Palmer walked by with his dog and waved. "Good ride," he called out. "Great ride," I replied. "Beautiful day out there. Glad to hear it. Hey, we are having a community barbecue next month. Hope you will come. I will be there." He continued on his walk and I closed the garage door. Inside my house, I made dinner and settled in for the evening. My life was good. The neighborhood was peaceful. The HOA was functioning properly. Patricia was gone. Justice had been served. Some people probably thought I overreacted by suing over a snow machine, but those people did not understand. It was never just about the machine. It was about the principle that no one, not even someone with the authority of an HOA behind them, has the right to destroy your property because they do not like you. The punitive damages the jury awarded sent a clear message to HOAs everywhere. Abuse your power and face serious consequences. The reforms implemented in Pine Ridge Estates showed that positive change was possible when people held their leaders accountable. I finished my dinner and looked out the window at the stars beginning to appear in the darkening sky. Tomorrow, I would go to work. This weekend, I might take the snow machine out again. Life continued on, as it always does, but I continued on with the knowledge that I had fought for myself and won. That knowledge was worth more than any settlement the HOA could have offered. It was worth more than the brand new snow machine sitting in my garage. It was the knowledge that I had agency, that I had power, that I could make a difference when I chose to fight. Patricia Whitmore had tried to teach me a lesson about respecting authority. Instead, she learned a lesson about the consequences of abusing authority. The judge made sure of that when he ruled in my favor and ordered the HOA to pay for a brand new model. Justice was not always swift, but when it came, it was sweet.